Every nation, every society builds itself upon a set of unspoken truths, foundational principles that guide its path and define its character. For the United States, one of these truths, perhaps the most sacred and enduring, has always been the unwavering belief that no one, absolutely no one, stands above the law. It is an ideal deeply etched into our collective consciousness, taught in classrooms from an early age, invoked with solemnity in courtrooms, and held as the ultimate safeguard of our democratic republic. We often envision Lady Justice, blindfolded, her scales perfectly balanced, dispensing fairness without prejudice, without regard for power, wealth, or title. This principle is not merely a legal concept. It is a profound moral compass, a solemn promise to every citizen that the rules apply equally to all, from the most humble individual to the highest office holder. But what happens when this bedrock principle, this sacred promise, is subjected to a test of truly unprecedented magnitude? What happens when the scales of justice are asked to weigh the actions of a former president, a figure who once commanded immense power and still inspires fervent loyalty among a significant portion of the populace? Today, America finds itself in precisely such a moment, navigating a legal landscape unlike any it has encountered before. We are witnessing a legal drama unfold that is not just historic in its scope, but truly without precedent in its implications. Donald Trump, a man who once held the highest office in the land, now stands at the epicenter of a storm of legal challenges, a confluence of investigations and trials spanning multiple jurisdictions. These proceedings could redefine the very nature of the American presidency, the boundaries of political power, and the enduring strength of the ruled law itself. This is not a single isolated incident, but rather a complex and intricate tapestry of allegations, each thread pulling at the fabric of our national understanding of justice, accountability, and the limits of authority. The air across the nation is thick with anticipation, with profound division, and with a deep sense of uncertainty about what the future holds for both the former president and the country he once led. Among these threads, perhaps the most explosive, the most direct challenge to the democratic process, are the allegations surrounding the 2020 election. Picture the scene: the aftermath of a fiercely contested election, the results certified by states and affirmed by numerous recounts and court rulings, yet a relentless campaign to sow doubt and overturn the outcome. Prosecutors allege that this was far more than mere political rhetoric or a challenge to election results. It was a concerted, multi-pronged effort to pressure state officials, to demand they find votes that did not exist, and to spread false claims of widespread fraud that had no basis in fact. We remember the widely reported phone calls, the public statements questioning the integrity of the vote, and the escalating tension that gripped the nation. And then, the culmination, January 6, 2021. A day that began with a rally near the White House and ended with an unprecedented assault on the United States Capitol. A violent attempt to disrupt the peaceful transfer of power, a cornerstone of American democracy. For those who believe in the sanctity of the ballot box and the peaceful transition of power, these allegations strike at the very heart of what it means to be a self-governing people. It forces us to confront the inherent fragility of our democratic institutions and the immense responsibility that comes with leadership, especially when the stakes involve the very foundation of democracy itself. Then there is another narrative, one that takes us back to the intense heat of the 2016 presidential campaign. This story involves hush money payments allegedly made to silence potentially damaging stories and to keep critical information from the public just as voters were heading to the polls. Prosecutors argue these payments were not merely personal expenses, but rather a deliberate and unlawful attempt to influence the election by manipulating public perception. The core of the charges revolves around the alleged falsification of business records to conceal these payments, transforming what might have been a private matter into a potential violation of campaign finance laws. This case raises uncomfortable and profound questions about the intersection of personal conduct, the strictures of campaign finance regulations, and the public's fundamental right to know. Was this a desperate measure to protect a candidacy from scandal, or a calculated subversion of the electoral process itself? The legal battle here is not simply about money or a private transaction. It is about the integrity of information in a democracy and the lengths to which individuals might go to control their narrative, even at the expense of transparency and fair elections. And finally, we confront the stark and unsettling image of highly sensitive national security documents, allegedly stored not within the secure confines of government facilities designed to protect such secrets, but at a private residence, Mar-a-Lago. The sheer volume of these documents, the array of classified markings they bore, and the inherent potential for compromise paint a chilling picture of risk. When the Federal Bureau of Investigation executed a search warrant, boxes containing hundreds of these documents were seized, sparking a national debate about the proper handling of state secrets and the established protocols for former presidents. The central question looms large. Did a former commander-in-chief knowingly obstruct efforts by the government to retrieve these vital files, thereby potentially jeopardizing national security and the safety of intelligence assets? This case profoundly challenges our understanding of accountability at the highest levels of government. The immense trust placed in those who hold the nation's most guarded information, and the delicate, often precarious balance between an individual's personal rights and the imperative of national security. Each of these accusations, each legal challenge, is met with a fierce and unwavering denial from the former president. Donald Trump insists he is the victim, a target of relentless political persecution, a witch hunt orchestrated by his opponents to keep him from power and undermine his future aspirations. He claims these are politically motivated attacks designed to silence a powerful voice and prevent his return to the national stage. For millions of Americans, this narrative resonates deeply. They see these legal battles not as a legitimate pursuit of justice, but as proof of a weaponized justice system, an attempt to silence a voice they trust, an affront to their chosen leader, and an attack on their values, their beliefs, and their vision for the country. They view it as an abuse of power aimed at a political opponent. But for countless others, these trials represent something else entirely. A long overdue reckoning, the justice system finally reaching for accountability, proving that indeed, no one, not even a president, is above the law. They see these proceedings as a vital defense of democratic norms, a necessary step to uphold the integrity of our institutions, and a powerful testament to the principle that power does not grant immunity or a shield from legal consequence. The chasm between these two perspectives is vast, creating a profound national division, a tension that pulses through every news cycle, every social media feed, and often every family dinner table. So here we stand at a crossroads unlike any before in American history. Never has a former president faced the possibility of criminal conviction. History offers no easy answers, no clear roadmap for this unprecedented journey. Richard Nixon resigned before the hammer of impeachment could fall, thereby avoiding a trial and potential removal from office. Bill Clinton faced impeachment by the House of Representatives, but was ultimately acquitted by the Senate, avoiding conviction. But Donald Trump's legal fights are pushing the nation into truly uncharted territory, a legal and political landscape where precedents are being set in real time, with profound implications for the future. The courtrooms become stages for national debate, the legal arguments scrutinized by millions. Every witness, every piece of evidence, every ruling carries the immense weight of history, the potential to reshape not just a political career, but the very identity of a nation. As the trials unfold, as the arguments are made and the verdicts awaited, one truth becomes undeniably clear. The America that emerges from this will be different. The legacy of Donald Trump, already a subject of intense debate and historical scrutiny, will be indelibly marked by these legal battles, regardless of their specific outcomes. But more profoundly, the future of American politics, the public's trust in its institutions, the integrity of our elections, and the enduring strength of our democratic principles will all be tested, perhaps irrevocably. The stakes are not just about one man's fate. They are about the very soul of the republic and what it means to live in a society governed by laws, not by individuals. Could Donald Trump become the first United States president ever convicted of a crime? Or will he defy the justice system, emerging as a figure who survived its greatest challenges, a testament to his resilience and the unwavering loyalty of his base? Either way, his legal battles are not just about him. They are about us. They are about what we believe, what we demand from our leaders, and what we are willing to fight for when the promise of equal justice hangs in the balance. The story is still being written, its final chapters yet to be revealed. But its profound implications will define American politics for generations to come, forcing us all to ask, what does justice for all truly mean in the 21st century?